Okay. All right, Darla, if you want to go ahead and kick us off, that would be great.
Absolutely. Well, welcome everyone. We are so excited this evening to have two wonderful individuals and friends, I might say, but going to give us some great information. And so welcome to the Special Needs Estate Planning and Family Law. To tell you a little bit about our guest speakers, Jennifer is a special needs estate planning attorney, and for over a decade, she has engaged in legal practices that include estate planning, probate, business, and real estate transactions. She founded Chiang Law Firm in 2014 with her husband as a small family business. Today, it is a fast-growing law firm serving clients in Greater Houston and abroad. She was a frequent author and presenter on estate planning and probate issues in the Greater Houston area. And in 2015, I love this, the Sugar Land City Council unanimously appointed Jennifer as an associate municipal judge for the city of Sugar Land. Jennifer has the distinction of being the first native-born resident of Sugar Land to serve as a municipal court judge, as well as the first Asian American to serve. Since then, Jennifer has dedicated herself to being a fair and effective jurist for the citizens of Sugar Land. And I might add, they have one young son and another one in the oven. So, Jennifer, thank you for being here, and we appreciate your support. So next we have Chris Meyer, who is a family law attorney dealing with high conflict divorce, custody, and family violence. He's a strong attorney. He is a Christian, husband and father, and a veteran of the United States Army and a local advocate for veteran issues. Christopher is the past commander of Disabled American Veterans, Chapter 233, Fort Bend County. He uses his skills and energies towards benefiting the veteran community and practicing law. His emphases are family law, divorce, and evictions. He quoted to us that he had spent several years advocating to Houston Metro on behalf of disabled veterans, and he's proud to say, as we are proud of him, to say that as of April 2016, Houston Metro is now offering free bus and rail rides to Houston disabled vets. I've personally known Chris and Jennifer for quite some time now. They're incredible community advocates. They have a love and passion for the special needs community and for the family unit. And we are extremely honored to have them present to our families and those, some we may know and some we don't. And so, Jennifer, I'll turn it over to you.
Hi, thank you so much, Darla. I'm going to take a moment to go ahead and start sharing the PowerPoint. And let's do this. Share. And we put it into presentation mode. Okay. So thank you everybody for coming to our estate planning seminar. We basically broke it up into two different ways. Estate planning for special needs families and then family law for special needs families. I don't know if Darla made it clear enough for you, but by the way, Chris and I are married to each other. We're both attorneys. We actually practice in the same building. And that's one of the reasons why we're both doing this today. I've known Darla for years. Years. I can't even say how many years, but I've known her through her work in the community and how strong of an advocate she's always been for special needs families and just the community at large. And I'm so proud to be able to present this presentation for Hope for Three. One of the things that I've done in my practice is I'm an estate planning, probate, and real estate transactional attorney, but I'm also a volunteer and I've also done CPS work in my past life, and I work closely with CASA. And I was recently involved with talking with some CASA leaders, and they said that, hey, we had an intake for a family member where the mother was a single mom who had a special needs child. She needed to go to inpatient treatment, but there was she had nothing in place to make arrangements for her special needs child. And so that child was going through an obviously traumatic situation, and there really wasn't any support in place. And so that gave me this idea to talk to Darla about, hey, do you think your members would find this presentation useful to talk about what kind of contingencies can you put in place as parents or advocates for special needs adults and children to for whatever may happen in life, where if you're not able to take care of them yourself, or your spouse isn't able to take care of somebody themselves, what can we do to create a plan so that there's always a continued continuity of care? There's always something in place. And so that's how this presentation was born. And I basically created these slides with that scenario in mind. Move on to the next one. A little bit about me. Thanks for my great introduction, Darla. I have a JD and an MBA from the University of St. Thomas, as well as my undergraduate degree from the University of St. Thomas, and my JD from U of H Law School. I've been practicing law in the Sugar Land area for about 15 years. And I've served on the board of a number of nonprofit organizations, everything from the Skeeters Foundation, which doesn't exist anymore, to the Fort Bend History Association, which still exists, and the Fort Bend Education Foundation. I'm a current board member, and I'm also a current board member of the Y Forever, and I do serve as an associate judge. My important disclaimer is I'm an attorney, but I'm not your attorney. And so, of course, nothing in this presentation should be considered as legal advice. And if you have a particular legal situation, I strongly encourage you to speak to an attorney and create an attorney relationship with that person. What to expect? I'm going to answer these 4 questions as part of our presentation. Number 1, what is estate planning and disability planning? What are the typical documents for an estate plan and a disability plans? Third, what are unique concerns for families with special needs children or adults? For example, guardianship, special needs trusts, Medicaid planning, etc. And last but not least, how to start your estate plan and disability plan. While I'm going through this, there might be some questions. We have questions times set up. We have time for questions set up at the end of the presentation after Chris presents. So we're asking you to go ahead and save those questions for later. Estate planning versus disability planning. What is estate planning? Estate planning is a process of passing your belongings, your stuff, your money to the people that you love after you pass away. Disability planning is related but different, and there's many aspects of disability planning, especially for families with disabled family members. So related to estate planning, disability is planning for, number 1, your care in the event that you become disabled, but also, number 2, the care for anyone else who needs care in your family that may be disabled. And so, as you can see, there's going to be a little bit of overlap in the plans, and one feeds into the other, but they are 2 different goals, which I'm going to get into as I go through the documents. Oops. Document-wise, typical documents for estate plans include, first, a will. The will is the most basic document for an estate plan. It's the foundation of an estate plan. It disposes of your estate property, usually the cars or houses or financial accounts or other assets that do not have a payable on death beneficiary. And the will typically names an executor, who's someone that is responsible for carrying out your wishes. Your beneficiary are the people who would receive your estate. Now, another important document is a revocable trust or trust. The most important aspect of a will, and that makes it different from a trust, is that generally speaking, wills always require probate, which means you have to go through the legal process of submitting your will to the court, and the court has to approve that will to verify that it's genuine and approve of the executor before you can take action on an estate. Trusts are a little bit different because they're designed to work outside of probate. So I like describing trusts as basically a big empty bucket that you can start titling things to go into your estate either at death or right now. And the trustees, the person who manages the assets that are in the bucket, and the terms of the trust will control when and how and where and who gets your estate without any court intervention. You may have heard of special needs trusts. Special needs trusts are closely related to these kinds of trusts, and you can actually have trust inside of trust inside of trust. It's like a big babushka doll, where I can set up 3 or 4 different kinds of trusts with 3 or 4 different terms, depending on what kind of situation that's called for in your family. Trust can get very complicated, so of course I would also encourage you to talk to your talk to an attorney about that. Special needs trusts are a different class of trust that could also be created by will, created by trust, or created all on its own. Special needs trusts specifically hold assets for disabled beneficiaries that need to qualify for government benefits, i.e. Medicaid. As many of you know, Medicaid beneficiaries can only have $2,000 in countable assets. Otherwise, if they have more resources, they get disqualified. This special needs trust tends to allow for a pot of assets to be available to a special needs person so that it doesn't jeopardize their Medicaid benefits. There's also a difference between first-party trusts and third-party trusts, and that really matters according to who is the person setting up the trust, and the rules are slightly different. The rules can get pretty complicated, which is one of the reasons why I strongly encourage my families to, if you need to qualify for Medicaid, you or your loved one needs to qualify for Medicaid, you really do need to talk to an attorney to make sure assets are structured properly so that it won't jeopardize your loved one's ability to qualify for Medicaid in the future. Other common documents that we use are to create non-probate estates. For example, a lot of my clients say, hey, why do I need to probate my will when all I have is a bank account, a house, and a car, and my wife is the joint account holder on my bank account. My wife is the joint account holder on the joint holder of my car, and my wife is the joint owner of the house. And I say, well, you're about halfway there. But the problem is that the laws in the state of Texas actually decide who your beneficiaries are. Sometimes it's your wife, sometimes it isn't. And the best way to override what the default is in the state of Texas is to actually have a will or to make designations in advance. So for example, I recommend doing transfer on death deeds. Transfer on death deeds basically create a right of survivorship between husband and wife if they own a property together, or it doesn't even need to be a husband and wife. It could just be 2 people who own a property together. And it could say, you know, first I want the other person to own the property. Then after the death of both of us, we want the property to go to someone else, i.e. your joint children. Transfer on death motor vehicle designations are incredibly useful as long as you own the title to your car. If you have a loan on it, you can't really use this, but transfer on death motor vehicle designations on most brand new or newish car titles, there's actually a small section on the bottom that says if this car title is issued in the name of 2 people who are married to each other, by signing this document, they both agree that the other person is going to inherit their share of the vehicle. And if you wanted it to be someone other than your spouse, you could actually fill out a motor vehicle designation form. I didn't list the form number down there, but if you Google it, you can find it. It's a form that is available from the Texas Department of Motor Vehicles. You get it, fill it out and sign it before somebody passes away. And just like a transfer on death deed, it'll be effective at passing a motor vehicle at death. And then, of course, for your financial accounts, like insurance policies, bank accounts, investment accounts, etc., we have transfer on death beneficiary designations that you can name with the institution, and that would name the beneficiary outside of court. The biggest issue, though, of course, is if you have a special needs adult in your life and you want them to be the beneficiary of a house, a car, or any money and that's in an account, you actually have to be very careful on how you set up your beneficiaries, because if it goes into their personal names, that special needs adults could have their Medicaid eligibility jeopardized because they have too many resources. And this is one of the reasons why we strongly recommend talk to an attorney, set up special needs trusts, and make sure your assets pass through the special needs trust so that your special needs adult could still have these resources, but not have it count against their Medicaid eligibility. Typical documents for a disability plan, especially a disability plan that involves you. The first document is a durable power of attorney. Your durable power of attorney names a person that you're appointing to make business decisions on your behalf. You can have the power of attorney effective now or effective only upon incapacity. And the power of attorney is only effective while you are living. So by the time you pass away, then the power of attorney is canceled. Also, if a guardianship over you is ever appointed, power of attorney becomes ineffective. It gets canceled. There are limitations to what powers of attorneys can do. For example, I can't, or your your power of attorney can't refinance your home using a power of attorney. And so power of attorneys are really good at doing a lot of things, but there are some certain limitations. I'd say they're good at about 80 to 90% of things that you want to do, but they just can't get you past the last 10 or 20%. Your medical power of attorney controls your healthcare decisions. Different kind of power. Unlike your durable power of attorney, where you can make it effective immediately or only upon your incapacity, your medical power of attorney really only comes in when you're incapacitated. If you can communicate with your doctors and nurses and tell them what you want them to do, your doctors and nurses are always going to do what you want and what they hear from you. Your medical power of attorney really only comes in when, say, you're in a coma or your doctors and nurses can't understand you. And that's when your medical power of attorney makes decisions for you. And again, it is also only effective while you're living. Your advance directive is a little bit different from your medical power of attorney. Those are instructions to your medical power of attorney to tell them what kind of decision you would like them to make in the event that a life-ending decision can be made on your behalf. And I generally tell my clients that, it's really not a legally enforceable document. It's more of a communication tool between you and your medical power of attorney. And your medical power of attorney will ultimately take all the information from your healthcare providers and come up with a treatment plan for you that they believe is consistent with your wishes. So ultimately, you really need to have a great discussion with your medical power of attorney on what you want them to do with your advance directive, just because those decisions aren't always black and white. And the next document I'm going to talk about is a HIPAA release. Your HIPAA release, generally it's a privacy document release. I've had clients where, I know everybody feels like they sign a new HIPAA release every time they go to a doctor, but you'll be surprised at how many clients that I have where they try to get medical records for their husband or wife or their child, especially an adult child. And basically the doctor's office says, absolutely not. You're not allowed to get their medical information because you don't have a HIPAA release. And especially as if you have young adult children who maybe they have a guardianship over them, maybe they don't, making sure that you have at minimum a HIPAA release, medical power of attorney and durable power of attorney for them, so that if you can help assist them make financial decisions and medical decisions, would always be my recommendation. But of course, you should probably talk to an attorney about your specific situation. Guardianship elections. Guardianship elections are another one of those documents where they are for you, but they're also for any disabled adult that you have a guardianship over. It informs the court who you want to serve as guardian, but also, maybe even more importantly for some families, who you don't want to serve as guardian for you or your child or your special needs adults that you are the guardian for. A little bit of vocabulary. There's 2 guardians that actually get appointed, guardians of the estate. And those are the people who manage the financial affairs for the ward. The guardian of the person is the person who takes care of the medical decisions, the health, as well as the educational and living arrangements for the person. Big note, once a guardianship is appointed, any power of attorney that was in effect becomes ineffective. And another thing about guardianship elections, because of course we do recommend them if you are the guardian of a special needs adult, to create a continuity plan, is to always also have a guardianship election for that special needs person as well. Who do you want to serve after you? One of the problems we have is if one parent may tell may tell your child, hey, please always take care of your sister. And then they just leave it at that. Well, if that sister didn't want to do it, or if there's nothing in writing, that there's nothing to say that the other sibling might come and swoop in, but the other sibling is also, someone who's a ne'er-do-well, who's been in jail twice for stealing money from women and children, which is exactly the wrong kind of person you want serving as guardian. Without anything in writing, there's really no instructions to the judge on what kind of person you would like to appoint for your special needs ward. Ultimately, though, it is the responsibility of the judge to appoint somebody, which is why it's just an election. It just tells a judge who you would prefer. It's not confirmed until the judge actually does the appointment and the person becomes the guardian, which is one of the reasons why I also recommend a caregiver agreement. So a caregiver agreement is a more informal document that I call basically like a power of attorney for your children or your special needs adult, that you can give someone else the authority to make decisions about healthcare or give consent to healthcare, or make educational decisions in your absence. In terms of your own biological children, both biological parents have to sign it. In terms of a special needs adult, the guardians have to both, whoever's appointed as the guardian needs to sign that document in terms of children. A SAPSR, which is a suit affecting parent-child relationship, can make the caregiver agreement completely ineffective. So you have to watch that. And I always tell my clients that, look, this is a Band-Aid. A court-ordered judgment, as far as a SAPSR goes or a guardianship judgment goes, that's always the best, strongest, and the most durable solution that will be respected the most. This caregiver agreement, it really depends a lot on the registrar at the school or the nurse checking you in at, or the receptionist at the doctor's office to make a judgment decision about whether or not they're going to allow this document to pass muster. So, but in the absence of having any other document, it might be better than absolutely nothing. So I strongly encourage my clients to really think through and think about the future and what contingencies they might need to go through to probably also not only have a caregiver agreement, but also consider getting guardianship elections as well. So unique concerns for your kids with, or special needs adults with disabilities, you really have to think about the nature of the disability. And I know I have autistic family members in my family as well. It's a spectrum. You really don't know, especially if they're a young person, you don't know what they're going to be like as an adult. That with certain therapies, you might have a young adult in your life who maybe they just don't get along with people, but they're really great at math, they're super smart, and they're college bound. Some other people on the autism spectrum, though, especially in my work in the CPS system, I have some children that I represented that are profoundly disabled, who are nonverbal, who are not even ambulatory and will definitely need care for the rest of their lives. So you really have to think about, okay, what does the future look like for this child or this adult? Is the nature of the disability lifelong, or is it temporary? Will their condition improve with time? Are they able to complete any education or job training? And maybe even most importantly, will they be able to hold down a job or live independently? And all of this goes towards Medicaid qualification, which is kind of the main bundle of disability benefits, SSI / SSDI and Medicaid. So to qualify for Medicaid, you're going to have to basically be disabled, but also have fewer than $2,000 in countable assets. And like I said, if your special needs child receives an inheritance of, say, $100,000 and it was left to them directly in their personal names, or payable on death through payable on death beneficiary, where basically they get cut a check for $100,000. Well, guess what? You thought you might be doing the right thing because they get their money directly, but they also just became ineligible for Medicaid. And generally speaking, the lifelong Medicaid benefits are going to be far greater than $100,000 for a person who qualifies for Medicaid. And so you really do want to be extremely careful about how you structure gifts to special needs persons, especially if they're going to need lifelong Medicaid. So will your special needs child or special needs adult need a guardianship? For certain special needs adults, number one, you can only get a guardianship, start applying for a guardianship when the child is going to become an adult right around 17 and a half. And so when they turn 18, the guardianship orders can be in place. It usually takes about 6 to 9 months to get. So by the time the child turns 18, that's when the final order is signed. So legal guardianship is generally only recommended for special needs adults who have profound lifelong impediments of holding down jobs and living independently. I generally say it is a lifelong commitment, because generally guardianships will remove complete financial and medical decision making from this person, and courts don't take that lightly. It also removes your ability to decide to get married, to decide to vote, to get a driver's license, to own a firearm, to serve on juries. I mean, these sound like little things, but actually, serving on a jury and having the right to vote, that's actually a constitutional right that's guaranteed by our founding documents. So they're actually very, serious rights, aside from the right to be able to decide how to spend your money or whether or not to do an invasive medical procedure. So you really need to think about, ultimately the what's in the best interest of the special needs adult that's in your life, whether or not they can operate independently on their own. Maybe they can have some kind of alternate support. So for example, I talked about doing durable power of attorney, medical power of attorney, HIPAA forms to get medical information. There's also supportive decision-making agreements where you're telling the doctors and nurses and people around you, the disabled person is telling the people around them that, hey, my mom or my sister or my brother, they helped me through to decide what to do with my money, what to do with my healthcare, and I want them to be there to support me through this. In addition, certain accounts like representative payee accounts through Social Security can also avoid guardianships, at least the guardianships of the estate. So again, the decision to get a guardianship over a special needs adult is a very complicated one, and one that I think you really should speak to an attorney about if you have any questions about whether or not a guardianship is right to you, because it really is on an individual case-by-case basis about whether it's right for your family and whether it's right for the special needs adult that's in your life. So lastly, I wanted to go over how to start creating a guardianship or creating a disability plan and a estate plan. The first thing I want you to think about is who are your fiduciaries and who are your beneficiaries. Fiduciaries are people you appoint to act on your behalf, and your beneficiaries are people that you designate to as recipients of your estates. And your beneficiaries can be anyone of your choice. They can be family members, charities, good friends. And same with fiduciaries. Your fiduciaries can be anyone you choose. It doesn't have to be family members. It could be friends. Really, it's just whoever's the most trustworthy people in your life. Probably the most important thing for families with special needs adults or children is to consider who are the people who are going to be making decisions for your special needs adult or child. Does that person have a good relationship with that person? What does a lifelong care plan for that special needs adult or child look like? And is that fiduciary, the person who's responsible for carrying out that plan, are they able to actually carry out that plan? And as much as we would wish that everybody in our family would be 100% on board, not a lot of people would be on board. You really have to have that discussion about whether or not they have the number one, the intellectual ability, the training, and the willingness to seek out advice from professionals to do the job, not just adequately, but do the job well. Next, what are your assets? Financial planners and CPAs are incredibly helpful in this aspect to making sure that your financial house is in order as well as your legal house is in order. I always say that lawyers are really just one part of an important tripod of professionals that everybody should have. Everybody should have a CPA to do the tax and numbers aspect of it. Everybody needs a financial advisor to be able to fund the plans that I create. And of course, everybody should have a lawyer to create the legal structure for an estate plan. And ultimately, I always tell my clients, I can create the most beautiful special needs trust that does every single legal trick in the book. But if you have zero assets to fund it with, there's really no point in creating a special needs trust. And so a financial advisor and a CPA can help you with that financial aspect to make sure that your assets are sufficient to fund any lifelong care that a special needs adult might have, and to make sure that the special needs trust that we might set up will be sufficient for their needs. And lastly, I recommend for you to talk to your loved ones, ask them what kind of role that they want to play, and what kind of life they envision, and whether or not they're willing to take on the role as a fiduciary, or what their life as a beneficiary might look like. And of course, I would hope then that you would talk to your attorney. And so that's it for me. Thank you so much for your attention. And I'm now going to pass it on to Chris Meyer to talk about family law.
Okay, great. Thank you. Thank you, Jennifer. If you don't mind, if you stop the screen share, I'd like to share something else with everyone just for a moment, please. All right. All right, let me add the spotlight. So hi, thank you everyone for coming. It looks like we got a really good crowd today. A lot of people on Facebook Live too, so I really appreciate that. I do want to screen share something with you guys before I really get started. I have a pretty popular podcast. We're on YouTube, and I did a interview of a Marianne Hughes. She's a special needs mom, and she's also starting her own little podcast and her own little special needs mediation to help other custodial parents of special needs children kind of navigate this process. It was a really good interview. It's up on my YouTube channel. And also, if you go to my website, you just kind of scroll down through my podcasts, get down to April, May. There we go. So special needs. Go down to May 16th. Okay, yeah, right. Okay, right here. Great. So just check out my podcast, check out my YouTube channel. I'll go ahead and share the link and directly to that interview, because for a lot of folks, I think this will actually help them out tremendously. So I'm going to share that down in the comments really fast before we really get started. So if you want to check out that interview with Marianne Hughes, wonderful lady. I encourage you to reach out to her, and also she has some of her own little other podcasts. So take a look and just take a look at what she has. Okay, so without further ado, I'm going to go to kind of get started on my part of the presentation, family law.
Do you want me to start screen sharing?
No, I'll go. That's not big. I got it right here.
Okay.
I'm going to. Just give me 1 second. Sorry. Yeah, if you want to go to the screen share, it would be nice. Sorry. My computer's streaming to all these platforms at the same time. Okay, so if we start out, what is family law? All right, first of all, let me go and meet this speaker, kind of talk a little bit about myself. All right, my name is Chris Meyer, and also I'm Jennifer Chiang's husband. We do have two separate law firms. She has Chiang Law Firm, mostly estate planning and probate, and she did a beautiful job telling you guys what she does. I have my own separate law firm, Chris Meyer Law Firm. We're in the same building, but I only do family law, and that's it. I am a licensed attorney. I graduated from Texas A&M back in 2005. I spent a few years in the Army, a little bit of time overseas in Iraq. Then after that, I went back, used my GI Bill to go to U of H. I studied pre-law, and then I went to Thurgood Marshall School of Law. While I was a 1L, that's when I met Jennifer. And well, we, everything just kind of took off from there. Great things. I'm also the past commander of Disabled American Veterans. If you don't notice my, can you show put me on the big screen for a second? Or spotlight me first. Yeah, you see my big poster right here, no drugs, no alcohol, no debt. I call that, DAD, drugs, alcohol, debt, or DAD's rule. That's kind of one of the reasons I was popular as the commander of Disabled American Veterans, because I was there. I understand PTSD. I understand how the circumstantial complexity of it, how it can affect your family life at home. And, I'm not on my, it's not my first marriage. I was, unfortunately, I was a young soldier. I got married young, and, I was young and dumb at the time, doing all the wrong things, going into the Army, the global war on terror. So, I'm very mindful about what, veterans go through, also what the military spouse goes through. It's also hell, because it's a tough job, being in the military or being a military family. So I'm very mindful of that. And I do know the danger, what drugs, alcohol, and debt can do to families, due to veterans, to their spouses. So I think that's kind of why I was popular, because I knew these things were dangerous. I knew these things were the Achilles heel. So I was very happy to take that position as a commander for a while. Unfortunately, after I passed the bar exam, I just got way too busy, and I had to step down, and because too many veterans were coming to me with all, the family law issues. And also part of kind of a subset, what I would do is also special needs family law. It's because every once in a while I might have a custody or a divorce matter that involves a child that's special needs. And we have to be very mindful of that and very careful. So let me first go, without further ado, go into family law. And then kind of explain what it is, and then how the special needs aspect adds like an additional different kind of flavor to the whole complexity. So, okay, so let's talk about, first talk about what is family law, what impacts a special needs child can have on a divorce or custody dispute. What is a custody dispute? What is the agreement? Child support, how does that get calculated if we have a special needs child? And then ultimately mediation. That's where we need to go to hopefully try to figure this out, because it will be complex if we have to go in front of the judge, and that's going to be very expensive. So can a slide, please? Okay, family law, my second love. Family law is the area of law that deals with the legal aspects of family relationships, such as marriage, divorce, child custody, child support, and adoption. In Texas, family law is governed by the Texas Family Code. Some of the common family law issues that I might handle might include divorces. That this involves the dissolution of a marital relationship and the division of assets and debts, and of course, child stuff, but we're going to get into that. Next is child custody, which can or cannot be part of a divorce. If there's a marriage in place and there's children of the marriage, then yes, the children will be part of the divorce. If the parents were never married, they just had a child, then we don't have to worry about the asset division. We just take care of the children. So let's talk about child custody. Child custody, this determines which parent will have primary physical custody of the children and how much time the other parent will have visitation. Now, under the Texas Family Code, we have something called a standard possession order, but it doesn't really work when you have a special needs child. So, and I will get into that. Child support. This is a financial obligation that one parent has to pay to the other parent to help support the children. And I will get into more detail on how that's calculated. Adoption, this is a legal process of taking a child into your family and giving them the same rights and responsibilities as a biological child. Now, I'm also a court-appointed CPS lawyer, and I'm going to be straight with you. Sometimes these parents, they have the rights terminated because they will not stop using very dangerous drugs. So the rights get terminated, but now that the rights are terminated, the next logical step is to get this child adopted. And sometimes these children in the CPS system, they're special needs. It's very sad. But the good news is there's a lot of good Texans out there willing to adopt these little Texans, even if they are disabled. So I'm really happy about that. Okay, paternity. This is the fun part of my job is, well, establishing paternity. And That's just deciding who the legal father is based off of, are they going to acknowledge paternity? Is their name on a birth certificate? Was the child born during the marriage? Do we have a DNA test? I mean, oh my gosh, I can go in so many directions, but the cool thing is, if I need to get somebody DNA tested, the judge has my back. All right. Now, a little other smaller area, name changes, doesn't really, not too relevant to special needs, but sometimes it's something that we are allowed to ask for if there's like a divorce and we need to change the name of the child. It can happen, but be very careful what you ask for because the other parent is allowed to object. Okay, and keep in mind, a family law, it can be very complex. It can be very emotional, and it's, oh my gosh, it's very important to have a family law attorney on your side because when we get into the courtroom, things move very fast and the judge is not going to slow down for you. The judge is not required to slow down for you. It's really important to have an advocate on your side. I feel so bad. I go to court. I have to sit through docket call. I see all these unrepresented parents. They don't know what's going on. They're lost. And if the other side has an attorney or the other spouse is maybe also pro se, but they really know what they're doing, I can really see people getting taken advantage of. It's really sad. So it's good to have an advocate on your side. So a few additional things you want to keep in mind about family law is the law presumes that both parents will be what's called joint managing conservators of the child. That's like 50-50 custody, meaning they will share the parental rights and duties. What is rights and duties? We call it the heads, meds, and eds, the sharing of educational, medical, and dental decisions. The way the family code is designed is it's very super rewarding and super cheap for parents who can get along. It's called co-parenting, getting along and sharing in the rights and duties, sharing in the educational, medical, and dental decisions, sharing in custody, being reasonable with each other. But once that fighting starts, the way the code is designed, it gets very expensive very fast. And if we go to mediation and they're still fighting, we got to go to trial, and you're looking at a lot of money. I tell parents all the time, it's cheaper to co-parent, it's cheaper to cooperate, it's cheaper to find common ground than to fight, because that's, I tell clients all the time, I'm looking at that new Ford Lightning pickup truck and I really like it. And if y'all want to keep fighting, just make sure you're making an informed decision. But for ethical reasons, I'm always trying to, I'm actually really good at getting to people who are fighting. I'm actually really good at getting them to come to the table, find a little bit of common ground, and try to work something out that doesn't involve court involvement. So people do like me a lot. They really do. And it's not because I tell them what they want to hear. It's because I manage expectations. And I usually tell them the worst day in court, and then I get them something better. So anyways, but the court will always consider the best interest of the child when making decisions about custody, visitation, and support. And there are also many factors the court will consider when determining the best interest of the child, such as the child's age, health, emotional needs, and the parent's parenting skills, and the parent's ability to provide a safe, stable, non-violent environment for the child. I'm always hammering that. Parents want to get primary custody. It's like, well, you need to prove these things. You need to prove you can provide a safe, stable, non-violent environment and act in the best interest of the child. And I'll coach them on how to get past a home study. That's not hard, and we're usually very successful. So we're happy about that. Okay, can we do the next slide, please? Okay, what impact can a special needs child have on a divorce or custody dispute outcome? Okay, number one, the court will always consider the best interest of the child when making decisions about custody or visitation. And that's not just special needs, that's every child. But we do have to take the special needs aspect into consideration. And again, the court will, when it comes to special needs, the court will place a greater emphasis on the child's best interest. So just keep being mindful about that. Some of these courts, each has their own website, usually at the top of the website. I know the Fort Bend County District Court 328th, at the very top of their website, it says, best interest of the child will prevail. in all cases. So that's just their motto, and they are not incorrect, and that is a correct application of the family code. Like, their motto is, we do what's best for the children. The parents who are fighting, well, you know what, that's not their priority. It's the children. Okay, so also the court will also consider the specific needs of the child, such as the type and level of care that the child requires, the child's emotional and developmental needs, and the parent's ability to provide those needs. The court will also consider the parent's willingness and ability to communicate with each other about the child's needs and their ability to work together to provide for the child. And I see this so often and so many times I get a contested custody matter. Oh my gosh, the client sends me so many screenshots of text messages where they're just fighting, and yeah, sure, we'll bring that into court, but the judge is not going to be impressed because all that's evidence of is they're not co-parenting. So good luck there. Again, it's cheaper to find common ground with the other parent. And also, the other good news is, even if the other spouse is pro se and they don't have a lawyer, I'm actually really good at, I have to make it clear, I only represent the one parent, the person who's paying me, and the person I have a representation agreement with, and I'm required. The state bar of Texas requires that I act in my client's best interest, and I have a duty of loyalty to them. But in considering all those factors, if the other spouse is pro se, they don't have a lawyer, I'll treat them with dignity and respect, kind of try to build a little bit of rapport with them. Find some common ground, and then just kind of like, hey, look, I'm going to go for the ask. I'm going to see if I can't get them to come to an agreement, but that will be more in my client's favor than their, but if they don't like it, well, they can hire their own lawyer. So, and if things get a little too nasty, then there's always a possibility that the court may appoint a guardian ad litem to represent the child's interest in the dispute, kind of be the eyes and ears of the court and make sure the child's not getting taken advantage of. Because here's the thing, if dad hires me for the divorce and mom has her own lawyer and they're both fighting and prioritizing their own interests, then the question is, who the heck is looking out for the child? Because the parents that each have their own lawyer, and the lawyer's job is to act in their client's best interest. So that's when we get a guardian ad litem involved. It's usually like a $1,200 flat fee. The parents usually split it. And then it's the guardian ad litem's job to go out there and talk to the child, maybe interview the parents, depending on what the tolerances of the parties are, and then provide some kind of recommendation to the court. But one thing that what the guardian ad litem will take a look at, and the court will examine, is to see if one parent is better equipped to meet the child's special needs, and that parent may be awarded primary custody. But I'm not going to make promises on behalf of the court, because stranger things have happened. Now, if the parents cannot agree on a custody arrangement, the court may order a more restrictive arrangement, such as supervised visitation, to ensure the child's needs are met. The problem with that is, if the judge orders a more restrictive custody arrangement, then, well, you know what, there's a little bit of joint and mutual liability between the parents, because the reason they had to go to court is because they couldn't come to an agreement outside of court. So careful what you ask for. If you're not going to accept reasonable offers outside of court, then you might not like what the judge gives you. So just be mindful about that. So it's very important to have a experienced family law attorney as your advocate in this process, because the discovery process can move very fast. And if you don't know what you are required to respond to and what you're not really required to respond to, you really want to have an advocate on your side to file the proper objections. Okay, so that's, can we do a slide, please? Next slide. All right, so let's go into the custody agreement. A lot of times parents, they don't really care about the child support. It's important, super important, especially if maybe the custodial parent isn't employed. That's critical. That's a lifeline. But for a lot of parents, it's not about the money. It's about time with your child. So that's why we're going to dig into the custody agreement. I'll get to child support later. A custody agreement is a legal document that sets out the terms of how parents will share the care of the child or children after a divorce or separation. It typically includes details about the child's physical custody, legal custody, and visitation. Physical time refers to where the child will live most of the time. It can be either sole physical custody, where the child lives with one parent, or joint physical custody, where the child spends significant time with both parents. Now, I don't want anyone to get freak out or get upset or anything, because we have this thing called the mutual agreement paragraph, where if you guys are co-parenting, things are good, healthy, we're finding common ground, we're sharing in the rights and duties, then as long as you guys are mutual agreement, then we can actually ignore the custody order and just do what's best for the children, and also kind of be mindful of each other's work schedules. So we can, because it's not realistic if one parent's has a firefighter schedule and the other one's a nurse, and they have, these nurses, medical professionals, and first responders, they have the craziest schedules. A standard possession order is just not going to work. That's why it's critical that they co-parent and come to an agreement, and they're actually allowed to deviate from the custody agreement as long as they're in agreement. The problem is, once we go back to fighting, then there is no mutual agreement, and we have to go back and follow the order, which can be very difficult and punishing, especially if you have a job that's not very flexible. Okay, so that was the physical custody. Now, legal custody. That refers to the parents' rights and responsibility, the rights and duties, like educational, medical, and dental decisions. Are we doing decisions are exclusive to one parent? Are they allowed to make these decisions independently of each other or by agreement? These are all things that going to have to get resolved at mediation. Mediation is something the parties have to go to prior to trial. The judge is not even going to hear the case until we've at least attempted mediation first. So hopefully we can hash out these issues, because if we can't, then the judge might issue something very restrictive, and parties aren't going to like it. Okay, the other big area of the custody agreement is visitation. That refers to the time that the parent who does not have physical custody spends with the child. Visitation can be supervised or unsupervised, and it can be scheduled or it can be flexible. It can be flexible, but that requires healthy co-parenting and the parties being in mutual agreement and no fighting. But again, if there's going to be fighting, then we have to follow the custody order. And then once there starts violations, and oh my gosh, going back to court, and that's a whole other rabbit trail and I could talk for 3 hours on. Okay, so the parents can agree on a custody agreement, and if they don't, the court will impose one. And that's when the court makes a decision based on what the court believes is in the best interest of the child. And again, if it's a special needs child, the court will place a greater emphasis on what they believe is in the child's best interest. And that's based off of the level of care required, emotional and developmental needs, and a parent's ability to provide for those needs. Again, it's good to have an advocate on your side if you're going through this. Next slide, please. Okay, child support. That's another big one. Okay, under the Texas Family Code, child support is typically calculated at the general rule is 20% of the non-custodial parent's net income. And then for 2 children, 25%, 3 children, 30%, 4 children, 35%. It just kind of keeps going up from there, but it caps out at 50. And there's also upper limits to prevent the child support from becoming excessive. And also for Texans who are ultra poor, like under $1,000 a month, that's their income. There's actually child support guidelines that break away, that deviate down. So from so you're not starting off at 20%; it's actually at 15%. But still, but those are more like the exceptions to the rule. Now, the interesting thing is when we're looking at a special needs child, we're actually allowed to deviate from guideline child support and focus more on what the cost of raising a special needs child, especially if they're enrolled in additional educational programs. Maybe they're in some type of special school that requires extra tuition, things like that. And also the court's going to look at the parent's ability to provide for those, special needs and deciding what's going to be calculated. Also, medical support, medical child support will also be factored in, because if the child is going to, MD Anderson regularly for leukemia treatments, we want to make sure those medical costs are being paid for somehow, typically through whichever parent has the better medical insurance. And then here's the other problem is, if we go to, what about unreimbursed medical expenses? So the child needs a medical procedure that costs $1,000, but the insurance only covers the first $800. That means we have $200 unreimbursed. What are we going to do about that? Typically, under the family code, the parents split the unreimbursed medical. That's pretty standard. But sometimes we can deviate from that based off of the needs of the child, the abilities of the parent. Maybe maybe if a child is special needs and they just can't, and there's just no way that the custodial parent's going to ever be able to find any other type of employment, then the non-custodial parent could very well be liable for the full unreimbursed medical. I mean, there's 1,000 directions this could go in. That's why we have to go to mediation and try to hopefully work these issues out. But the good news is, if you have a special needs child, you are allowed to ask for a higher amount of child support. This is because of the special needs that a child will require more care and expenses. Okay, can we have a next slide, please? All right, mediation. What is mediation? Okay, so let's do this. We have a mom and dad, or man and woman. They get married or they don't get married, but they have a child together. And then things don't work out between mom and dad, and the child happens to be special needs. So if it's a divorce because there was a marriage, let's walk it through that. There's a property division and child stuff. Now, if the parents were never married, they maybe had a child out of wedlock, it's not uncommon, then there's probably not going to really be a property division, but definitely child stuff, and definitely we're going to have to talk about the rights and duties, child support, and what the custody and visitation is going to look like. Now, here's the problem. Special needs cases are more complex, and with all family law cases, the judge is, I'm speaking figuratively, the judge is not going to let you even drive past the courthouse until you've gone to mediation first, because the judge is not going to hear the case. Mom and dad are fighting, something's going on. The judge is going to say, well, did you attempt to settle outside of court? And the judge might say, okay, well, what mediator did he go to? And I say, oh, we went to so-and-so. What was the date? And if you're not prepared to answer that, if you're not able to answer that question, they're going to say, go back to mediation and kick you out of the courtroom very fast. It happens so often. So again, let's back step a little bit. Mom and dad had a baby, special needs, things don't work out. Now we need to figure out how we're going to raise this child. So one of the parents files a SAPSR. That's a suit affecting the parent-child relationship, or just, custody lawsuit, or a divorce petition based on what the relationship, how the relationship was characterized. So something was filed with the court. It's a custody lawsuit or it's a divorce, either one. Now, the next step is we need to get something in place to kind of like a temporary agreement to kind of govern the status quo, rights and duties, child support, while we figure out the rest of the case, which could maybe take several more months. And that's called temporary orders. It's like a quick Band-Aid to address child support, where the child's going to live, things like that. Temporary orders requires a hearing from the judge, but did I not say earlier, the judge isn't going to hear your case until you go to mediation first. So we got to go to mediation. So we're going to go to mediation on temporary orders. Hopefully, we can figure out the custody schedule, child support. The parents will be required to turn over financials prior to mediation, so we can figure out what the child support is going to be at. Also, sometimes maybe the diagnosis of the child is in dispute. Maybe the child had a like leukemia, but but it went to remission. You know, they're in the no longer diagnosed with leukemia, but it could come back. You know, and then these are the things we're discussing at mediation. And is the child sick or is the child not sick? It's really sad when, you know, someone who they don't want to pay child, or they don't want to pay above guidelines, so they're arguing the child is not sick. And, you know, now we have to bring in the medical records and try to decide, okay, is this, you know, is this child currently not special needs, but he will be again in the future? I mean, there's so many directions this can go. That's why it's so important that we try to figure it out in mediation. And again, mediation is a process where we have a mediator try to go between the two parties and find something in the middle that both sides are going to live with or can tolerate. So the mom will be in one room with his or with her lawyer. The dad will be in another room with his lawyer. Typically is on Zoom. So we're in two different Zoom breakout rooms. And then the mediator kind of bounces back and forth and tries to figure out something in the middle that the parties are willing to tolerate. Now, the cool thing is the rules of evidence, the rules of civil procedure, all the courtroom rules, they don't really apply in mediation. So you can talk about whatever you want, which is great. There's a lot more flexibility and it's a lot more informal in mediation. That's your chance to kind of make your legal arguments. And also, maybe it might be a humbling experience because the mediator will also tell you where you're weak in your case. So, but you know, take some good notes, and if it's clear mediation isn't going to work, and you're definitely going to end up going to trial, then at least hopefully the mediator gave you a little bit more clarity on what you need to work on in order to be successful at trial. But again, 3 things can happen at mediation. 1, we come to an agreement. Great. We can get those temporary orders, get that child support paid, get the rights and duties settled and the custody, not really any court intervention. That's that's generally what we try to aim for. And about 90% of cases settle in mediation. So parents are really happy about that. We don't have to go to an expensive trial. Okay. The second thing that can happen is reconvene. Reconvene means we're not in agreement. Or no, reconvene means just too many issues. Maybe it's a big divorce, a lot of assets, a lot of liabilities, a lot of little kiddos in this divorce, and we're just not going to be able to cover everything at once in one day. So we're going to have to come back another day. And yes, it will be expensive, more expensive for the parents. But sometimes these mediators, instead of reconvening, they'll just go into overtime. It's still cost the client, but it's actually in the long run, it's actually a lot cheaper than going to trial. And the cool thing is we can at least wrap it up in one day. But if we have to reconvene, then we have to reconvene. It's not very typical. It's mostly we're in agreement or we're not in agreement. Now, the third thing that can happen is we're not in agreement. It's called an impasse, meaning we're not in agreement and we're not going to reconvene. If you get an impasse, that means we're going to have to go to trial. Now, the cool thing about the impasse is sometimes we know it's not going to settle at mediation. There's just too much conflict. And you know, sometimes we want to go to trial because we know we're going to get a better day in front of the judge because maybe they're not going to agree to something that's reasonable, but we know the judge will order it. So it's better to just let it impasse and we'll just go to trial and let the judge and roll the dice in front of the judge. It happens all the time and it's fine. But hopefully I do make a good faith effort to try to get the clients to settle if there's room to settle. But if my clients are willing to accept reasonable offers and it's been 4 hours and they haven't budged 1 inch, yeah, we're probably going to go to trial. So I'll just tell the client, look, it is what it is. This is what we have to do. They're trying to go for sole management conservatorship, primary custody, and give you nothing. Then yeah, and there's no evidence to support why they should get that much extra time with the child when there's like no family violence or anything like that, and the non-custodial parent wants to be involved in the child's life, then yeah, at that point it's probably better just go in front of the judge and let the judge make a decision. So that's kind of where the purpose of mediation is, to hopefully try to settle it. It really is a lot more cost effective. It's a cost effective alternative to litigation. It's a lot faster than going litigation. And also because we don't have to go in front of the judge and start testifying against each other, it actually preserves the relationship between the parties. And the parties actually have a lot more control. And before I'm going to go ahead and wrap it up, I will leave you on this though. If at mediation is the one time in the entire custody process when the parent is going to have the highest level of power, and that's 50%. The other person with the 50% of power is the other spouse. And the judge has 0. The parents have all the power at mediation if we can come to an agreement within the family code. Now, here's a problem. If the parents are not in agreement, then they surrender, each side surrenders their 50% power and the judge gets 100%. So if the parents want to have more control over the outcome, it's better to find something in the middle that we can agree on, or you make the lawyers rich and the judge is going to might render a decision that the parties don't like. So I always tell the parents it's cheaper to cooperate, but sometimes if it's just clear the other side is not being reasonable, then we just have no choice but to go to court. But I'll leave you at that. Go ahead and open it up to any questions. And if it's kind of if you have a question, that's great. If it gets a little too confidential, maybe it would be better to email me and we can talk about it offline. But yeah, thank you for your time. And it was really fun sharing in today's webinar. All right. If you want to turn on your microphones, if anyone has any questions.
You want to stop the recording?
Yeah, I'll go ahead. Okay, I'll go ahead and stop the recording. That way no one's personal questions are out there on the internet. So I'm going to stop the recording now. Thank you, guys.